The English legal system treats free speech as an 800-year collision between public liberty and state power. It differs from the American model of a fixed constitutional wall. Here, the boundaries of expression are a dynamic battlefield. In medieval England, the concept of a right to speak was non-existent. This was the permission model. You spoke what the crown and the church allowed, or you didn't speak at all. The stakes were absolute. Criticizing the king was treason. Deviating from religious doctrine was heresy or blasphemy. The state didn't just suppress dissent. It used brutal public punishment to maintain its monopoly on truth. This reflected a specific philosophy. Speech was dangerous. To an insecure authority, unchecked ideas were tools that could destabilize the entire religious and social order. The arrival of the printing press changed the math. Political and religious arguments could be reproduced at a scale the state could no longer ignore. The Tudor regime responded with prior restraint. They established a licensing system where every book required official authorization. The goal was to choke the technology by stopping ideas before they were even printed. Resistance emerged from two fronts. Members of Parliament began demanding the right to debate without royal interference, while writers like John Milton argued in Areopagitica that truth was best found through open intellectual contest rather than advanced censorship. The first major victory came in 1695, when Parliament simply allowed the licensing laws to lapse. This shifted the entire nature of the fight. The state could no longer stop you from speaking in advance. Instead, the focus moved to punishing you afterward if what you said was deemed unlawful. This created residual liberty. Under English common law, you were free to do anything the law didn't prohibit. Your freedom lived in the gaps between specific restrictions. Throughout the 18th and 19th centuries, reformers pushed against these boundaries. Figures like John Wilkes challenged arbitrary arrests for political criticism, while mass movements like the Chartists campaigned for political representation. They even dismantled the taxes on knowledge, fiscal duties designed to make newspapers too expensive for the working class. The state retaliated with specific legal strikes. They used lethal force at the Peterloo Massacre, prosecuted radicals for seditious libel, and established the Hickland test, a restrictive obscenity standard that could ban a book based on a single passage. By 1900, England had a vibrant culture of debate, but it was legally precarious. Freedom existed only as long as Parliament chose not to legislate against it. The World Wars pushed this residual model to its breaking point. Parliament utilized its legal sovereignty to enact sweeping emergency powers. Under acts like Dora, the government exerted vast control over information, censoring the press and restricting any speech it felt might damage national morale. This exposed the system's core vulnerability. Because there was no supreme constitutional guarantee to stop it, a threatened parliament could legally strip away almost all expressive freedom. The experience of total war and the rise of international human rights movements forced a change. The leftover space model of liberty was no longer enough for a modern democracy. The turning point was the Human Rights Act 1998, which finally incorporated the European Convention on Human Rights into domestic English law. This introduced Article 10. For the first time, speech was recognized not just as the absence of a law, but as a positive fundamental right. But it is a qualified right. The state can still restricting speech, but it must now justify that interference against specific legitimate aims, such as national security or the rights of others. This created a four-step test for the courts. Any restriction must be prescribed by law, pursue a legitimate aim, be necessary in a democratic society, and be proportionate to the objective it's trying to achieve. This new focus on proportionality dismantled old Victorian standards. In 1960, the landmark trial of D.H. Lawrence's Lady Chatterley's lover shifted the focus from potential offense to the public interest in literary merit. English law moved from the medieval world of permission to a framework built on legal justification. Today, instantaneous digital communication and global terrorism have restarted the arms race. In response to these modern threats, Parliament has passed the Terrorism Acts and the Online Safety Act of 2023, targeting the encouragement of violence and specific forms of digital harm. At the same time, ancient legal weapons have been retired. In the late 2000s, Parliament officially abolished the common law crimes of blasphemy and sedition. There is no single, general hate speech law in the UK. Instead, modern restrictions rely on statutory tests that require specific elements, like the intention to stir up hatred, to be proven in court. The 800-year evolution of English free speech has resulted in a balancing act. It is a system that protects the right to offend and disturb, while allowing the state to intervene only when it proves a restriction is truly necessary.